Good morning, members of parliament, support staff, radio listeners, TV viewers, those following via social media, visitors in the public tribune, and members of the media. Welcome to the continuation of the urgent public meeting number 13 of today, Friday, May 23rd, 2025. I would like to give a special welcome to the Honorable Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes, and his support staff. We have established a quorum of 8 members. Please stand for a moment of silence. Thank you. I have received notice of absence from the following members: MP Sarah Westcott Williams, MP De Wever, and notice of lateness from MP Rayon Peterson. Before I go over to the notifications, I would like to take the opportunity to congratulate MP De Wever on her birthday. Does any member of parliament has a notification? That seems to be the case. MP Doran, you have the floor.
Thank you, Madam Chair Lady. Good morning to you, my colleagues, the Honorable Minister, his support staff, and a special good morning to the people of St. Martin. Madam Chair, I was out for a while for medical leave. I just want to thank everyone that reached out and appreciate the well wishes, and I will get back to all the answering as soon as I can. Thank you once again, and much appreciated, and it's good to be back to continue to serve the people.
Thank you, MP Doran, and welcome back indeed. I will give the floor now to MP Labega. And before I go over to giving the floor to MP Labega, I have also notice of absence from MP Lewis and notice of lateness from MP Otley and MP Kotai. MP Labega, okay. MP La Cruz, you have the floor.
A blessed morning, Madam Chair Lady Griffier, Minister and his support staff, my fellow colleagues in Parliament, and those listening and watching through social media. Madam Chair Lady, this morning I received a very disturbing video of a fight in a school where a child was knocked out. And I will definitely like for the Minister of Justice to receive that video and take that, and the Minister of Education, and take that video extremely serious, as it is now becoming a trend to videotape while a specific child is being bullied or beat down in a school, and that is something that we definitely need to pay attention to here in St. Martin. We do not want this here on St. Martin. Thank you, Madam Chair Lady.
Thank you, MP La Cruz. Seeing the notification of MP La Cruz, I also would like to warn the public that sharing those videos is punishable by law, so please do not entertain sharing those graphic videos. Is there another member of parliament that would like to have the floor? That does not seem to be the case. Thank you for your notifications. We have as agenda point for this public meeting, deliberations with the Minister of Public Housing, Spatial Planning, Environment and Infrastructure regarding the delayed publication of building permits and ensuring legal compliance and procedural clarity under IS number 654-2024-2025, dated February 24, 2025. Before we go over to the agenda point, as this is a public meeting, allow me to remind you of the introduction of the usage of interruptions during public meetings. The following guide applies in accordance with Article 43 of the Rules of Order. The chairperson may permit interruptions. These interruptions should aim to seek clarification, challenge assertions, or contribute additional information, and should consist of brief remarks or questions without introduction. The chairperson will ensure order and decorum during the meetings and the use of interruptions. Members, ministers, and guests must maintain parliamentary decorum and refrain from making offensive or disorderly interruptions. Members will be allowed 3 interruptions per agenda point. The interruptions are to be posed from the lectern placed in the Legislative Hall. We now go over to the agenda point. On February 24, 2025, Parliament received a letter from MP Doran, MP York, and MP Irion with a request that the urgent public meeting of Parliament be convened to discuss the above-mentioned agenda point. The presence of the Minister of Romy was also requested. The meeting was convened on March 12, 2025, during which, after a presentation by the Minister of Romy, in accordance with the speakers list, members of Parliament were given the opportunity to pose questions to the Minister in the first round. The meeting was then adjourned to allow the Minister to prepare the answers to the questions posed by the members of Parliament in the first round. The continuation was scheduled to be held on March 26, 2025, but was postponed upon the request of the Minister. The continuation meeting was held on April 7, during which the Minister provided the answers to the questions posed by the members of Parliament in the first round, including clarification questions. Immediately thereafter, in accordance with the speakers list, members of Parliament were given the opportunity to pose questions to the Minister in the second round. The meeting was then adjourned to allow the Minister time to prepare the answers to the questions posed by the members of Parliament in the second round. I will now go over to giving the floor to the Honourable Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes, to answer the questions posed by the members of Parliament in the second round. Minister, you have the floor.
Good morning, members of Parliament, those listening in the Tribune, those listening online or other social media outlets. Madam Chair, through you, I'll begin immediately with the responses to the questions, beginning first with the questions of second round posed by MP R12 Irion. Will the Minister be using ministerial decrees to grant exemptions or regulate civil works permits on a case-by-case basis or establish a general policy decree? Stated in my presentation, the Ministry is busy finalizing a ministerial decree to regulate the criteria for civil works permit. Since the presentation, I'm happy to announce the initiative is in its final stages and receiving feedback from all stakeholders. This is, of course, based on Article 28A, Sub 12, Landsverordening Ruimtelijke Ontwikkelingsplan. A ministerial regulation is currently being created. And of course, the stated is to regulate the criteria for when a civil works permit is necessary. Will a formal grace period be granted for projects needing to comply with civil works permit requirements? If so, what are the details and the timeline? At this time, due to ongoing capacity issues in the Ministry, we are managing the implementation of civil works permit requirements on a case-by-case basis. The decision to grant a formal grace period depends on specific circumstances of each project, including its current stage and the remaining scope of work. As such, we are not in a position to establish a uniform grace period or timeline applicable to all projects. However, I want to emphasize the Ministry is committed to ensuring a fair, consistent, and transparent approach to handling all applications. We will continue to engage with all stakeholders to provide guidance and support during this transition period and remain focused on strengthening our internal capacity to fully implement the requirements in the near future, as stated with the draft regulation. Will there be a public awareness campaign specifically focused only on civil works permit requirements? With the finalization of the regulation related to civil works permits, there will indeed be a communication around the new policy. This forms part of the larger communication plan of the Ministry. Since permits issued during the Minister's tenure may lack civil works permits, why were they issued without them? Is there a plan to rectify this, potentially by halting those projects until they comply? As mentioned before, until a few months ago, the Ministry was not fully aware of Article 28A of the Landsverordening Ruimtelijke Ontwikkelingsplan, nor had it been correctly implemented since its implementation in 2021. Due to the ongoing capacity constraints, the Ministry is currently prioritizing large impact projects to ensure they comply with requirements for civil works permits. This determination depends on the current stage of the works, as mentioned before, and what remains to be completed. Permits issued during my tenure may have lacked civil works permits due to oversight. Going forward, the Ministry will take necessary steps to ensure compliance, and if required, projects will be halted as a last resort. This is not only to uphold the law, but also to safeguard the environment of St. Martin. What are the precise legal status and weight of the draft zoning laws, plans, Is it considered policy, a guideline, or something else? The draft zoning plan has no legal status and is considered as a guideline. Given that these plans were made in consultation with the public, we have used these plans as a guideline when advising on construction developments. This is important to note that using the draft zoning laws plans over time is still noteworthy and has been confirmed by the court during a recent court case. The draft zoning plans also play a role in relation to Article 22, Sub 5 of the Building Ordinance, which can be used to deny a permit. That the building or part of the building, due to its location or method of construction, will be unsightly, a nuisance, or a fire hazard to the surrounding area. For instance, if in a residential area, all buildings are not allowed to be higher than 9 to 12 meters, this height is also mentioned in the draft zoning plan and development plan. You cannot issue building permits without expecting neighbors to justifiably make an objection or go to court. For a building of 14 meters or even 24 meters high. 3 such permits issued by the previous administration are now all in court because 3 neighbors started a procedure. 1 has already been fully annulled, and we're expecting government to potentially also lose the other 2 cases of this exact same nature. What is the formal public consultation process, like a town hall meeting conducted? Was a formal public consultation process, like a town hall meeting conducted for the current draft zoning plan. Currently, there are 13 draft zoning plans and 1 formally established zoning plan for Fort Amsterdam. From the 13 draft zoning plans, all of them were presented in town hall meetings to the public during the period 2013 to 2014. 5 of them went even further by being presented to a public hearing at which the public could send in their objections. These 5 plans are for Simpson Bay, Cahill Little Bay, Cul-de-sac, Middle Region, and Dutchwater. The public hearings holds more weight than a town hall meeting because of the fact that the plan can formally be appealed thereafter. Regarding a specific construction case on Pondfield Road allegedly impeding a government project, what enforcement action, stop order, demolition order, permit, check has the minister taken or will take? The question was posed to, through you, Madam Chair, to MP Irion as well for clarification as to what exactly project he's speaking of. And of course, if he can give that clarification, we will, of course, give comment if possible. How does the ministry handle a situation where someone holds an irrevocable building permit but is subsequently denied a civil works permit for the same project? Wouldn't it be more logical to grant an exemption from the civil works permit requirement for those already holding irrevocable building permits rather than requiring a separate application? Where an irrevocable building permit is granted but a civil works permit is later denied but has not occurred, each case is assessed individually, especially when projects have significantly impacted or at the advanced stage. A building permit covers vertical construction, while a civil works permit addresses essential ground infrastructure works, requiring separate review. Automatic exemption is not granted as both permits serve distinct regulatory processes. However, the ministry carefully weighs all factors before making its final decision. Does the ministry intend to pursue every past project with a building permit but lacking a civil works permit? If not, what criteria will determine which cases are pursued? Is it mandatory for owners of already completed buildings to retroactively attain a civil works permit if they don't have one? What is the plan? The short answer, no, MP Irion. There is no plan at all to retroactively request civil works permits. These are, of course, evaluated on a case-by-case basis as it arises. Moving to the questions of MP Christopher Weaver, if a developer holds a building permit but lacks a civil works permit, can they resume construction as originally approved once the works permit is applied for and/or attained? The applicant cannot resume or start construction before a civil works permit is obtained. As mentioned before, Because of capacity issues, this will depend, of course, on the scale and scope on how we move forward when it comes to civil works permits. Is the minister willing to proactively sit with affected developers, provide a clear checklist of missing requirements, and outline a path of compliance? Yes, this is what we currently do and have done in every situation that has arisen during my tenure. Would the minister consider allowing construction to continue under provisional approval while a submitted civil works permit application is processed, especially as initial lack wasn't the developer's fault? Again, this depends on the impact overall to the environment, residents, and the project status, and what works have been done already and what still has to be done. Moving now to the questions of MP Darrell York. Does the ministry have the capacity to handle the increased workload implied by enforcing civil works permits for all projects? While the ministry does currently have a challenge with capacity, we are in the process of hiring more evaluators. In addition, the introduction of the policy handbook for civil works is completed. Once the policy handbook is completed, it will help guide the ministry in handling the workload more efficiently. What criteria defines an issue that would trigger the ministry to review a past project's lack of civil works permit? Is it based on objective facts or subjective concerns? The ministry considers both objective factors and, where necessary, professional judgment when reviewing past projects that may lack a civil works permit. Key criteria includes the scale and potential environmental impact of the works, the current state of the construction, and whether the project poses public safety or infrastructural risks. The ministry is currently prioritizing large-scale projects as it relates to the request for civil works permits. Reviews are, of course, guided by legal frameworks, including Article 28A of the same Landsverordening Ruimtelijke Ontwikkelingsplan, which until recently had not been fully or correctly implemented. The goal is enforcement, not only to uphold the law, but also to protect the physical and environmental integrity of St. Martin. Can the minister explain the differences in enforcement action, warning versus stop order, taken against Villevin project compared to Westview project? The inspection department issued a warning to Villevin for carrying out civil works without a permit present on site. Westview project was issued a stop order for carrying out civil works without a permit. Warnings are issued when projects are being carried out, and it cannot be proven at the time of the visit if there's an existing permit or the building is not in accordance with such. A stop or removal order is issued when it is proven that there is no existing permit for the project or is not in accordance with the issued permit. Removal is in the event that the project cannot be legalized or the violator refuses to comply. Why are other options or solutions being considered for some projects while the Westview project received a stop order? What are the options? In cases where projects encounter permit-related issues, the Ministry of Bromley generally aims to resolve matters through dialogue first. Project developers are typically given this opportunity to apply for necessary permits or bring their activities into compliance with existing regulations. However, in the case of Westview project, the developer failed to cease construction activities despite not having obtained the required civil works permit. Repeated requests to halt the works were ignored. As a result, the ministry was left with no choice but to issue a formal stop order to enforce compliance. How does the minister ensure, How does the minister ensure the climate change considerations are applied consistently to government's own infrastructure projects as well as private developments? The ministry ensures consistent application of climate change considerations by enforcing planning and environmental regulations that include climate resilience standards. Both public and private projects must comply through permitting processes, including environmental impact assessments when required. The ministry's policy department includes climate experts who are consulted as needed to guide and review projects. Coordination with relevant agencies and technical guidelines further support climate resilient development. Why were the building permits issued under the minister's tenure not accompanied by the required civil works permit? Again, we stated before, we were not aware of the non-application, proper application of the article of ordinance that we request. Thus, we have rectified this and are now working to implement it properly, as stated before. Can the minister provide a definitive, unambiguous answer on whether individuals with existing applications for government land need to formally reapply under the policy? Very quick and short. Those who have previously applied for a specific piece of land and that application is present in the physical or digital archive of Domain Affairs and our government will not be required to reapply. Moving to the questions of MP Egbert Doran. What is the view of holding past department heads accountable for misconduct? The MP was making reference to a case where department, yes, okay, through you, Madam Chair, the MP was making reference to a case where department head allegedly asked Alegria what they would like to pay for use of government property. The ministry takes all concerns related to past or present misconduct seriously. While I cannot speak to the specifics of this case mentioned, I can say that if questionable actions are brought to our attention, they are looked into carefully and responsibly. Where necessary, steps can be taken to correct any past irregularities, always with the goal of maintaining transparency, fairness, and trust. Can the minister clarify if Ville-Vin's building permit was reissued in 2025 as suggested in some articles? The building permit for Ville-Vin was not reissued in 2025. Is the minister willing to conduct a full audit of the Ville-Vin project permitting process and provide all documentation to Parliament? Indeed, there are currently 2 requests for Lob Verzuke for the Ville-Vin project, and of course, if requested, the documentation can of course be shared with Parliament. Did the original Ville-Vin building permit issued in 2023-2024 include approval for the beach development, a marina, or breakwater? The building permit is for the physical building related to the project, not the beach development, marina, or the breakwater. Why did construction work at the Ville-Vin site appear to continue recently despite the public statements regarding the need for environmental impact study? The ministry issued a warning letter. However, no stop order was executed. Can the minister identify specific instances of misinformation regarding Ville-Vin project or others spread via media and provide the correct factual information? Through you, Madam Chair, none that I can think off the top of my head, but if the MP can share what misinformation he may be alluding to, then I'm more than willing to comment. Hypothetically, what approach would the current minister have taken regarding development projects and permit processes if he held the position from 2020 to 2022? Very shortly, a few things. A more comprehensive approach to development would have been pursued, ensuring that necessary infrastructure was put in place to support development. Transparency around why deviating from established practices and draft zoning laws were done, so the public would better understand the thoughts behind the minister's choices during this time. Given that the minister attended the Ville-Vin event and mentioned partnership, what specific benefits does he see the project bringing to St. Martin? I want to reiterate once again the reason for the term partnerships. In the voice note played by the MP, he failed to include the part where I stated and restated here on the floor of Parliament that anyone willing to consider environment and do things to correct the past and move forward is a partner. The assessment as to the benefits of the project needed to be made when the permit was signed. Does having an irrevocable building permit supersede the need to separately obtain a civil works permit for related activities? As stated in the reply to MP Irion, as stated in the reply previously MP Irion, and in addition, there's no such thing as an irrevocable building permit. There are 2 reasons to revoke a building permit, and this is if you don't build within a year, of course with some considerations if they're made, or if building permits are not being executed according to permits. To answer this question, one does not supersede the other, and this was confirmed in the recent verdict concerning Westview. If the building permit drawings already detail work like sublevels, wouldn't requiring a separate civil works permit for those specific building activities be redundant. As stated in round 2, civil works permits deal with how the entirety of the parcel of land is used. This includes excavating, removal of trees, and filling. A building permit is solely for the structure being built in one area of an entire parcel of land. While a building permit may detail work of several sublevels, it does not tell us what is being removed from this property around it, how the property will be used, or where the excavated material will go. As such, requesting a civil works permit is not redundant. How does the ministry apply the denial grounds for civil works permits when an applicant already holds an irrevocable building permit on the same property? This would indeed create a complex situation and one that has not occurred before. If such a case were to arise, it would present a serious legal and administrative challenge to the ministry. The ministry would have to assess the matter carefully within the bounds of the law, seeking a solution that respects both the integrity of the permitting process and the rights already granted. Our priority would be to handle such a situation with full transparency, legal clarity, and the best interests of St. Martin. Who signed the permit allegedly in 2012, allowing beach development at Indigo Bay to rejuvenate a sandy beach? A permit for the Rocky Beach rejuvenation was submitted in 2007 under number 149-2007 K-Bay Development LLC. During this time, this would have been done by the Lieutenant Governor. The ministerial decree that followed would have been signed by the then Minister of Rummy. What are the benefits of the minister? Okay, it's the same question. Moving on now to the questions of MP La Cruz. Will the ministry visit coordinating with the Ministry of TEAT to publish notices and permits for commercial and business licenses? Indeed, there is continued collaboration, but there's always, of course, room for improving and making sure that all communications align. Can the minister clearly explain the specific conditions or types of work that trigger the requirements for civil works permit? Does a building permit sometimes inherently include authorization for related civil works, or are they always entirely separate permits? As described in sub 1 of Article 28A, Lands for Ordering Spatial Development Planning, a civil works permit is necessary for the following works. A, the excavation, raising, leveling, or blasting of the soil. B, the construction of roads and other surface pavements. C, works and activities that may affect water management and the groundwater level. D, the felling or cutting of trees and the clearing of vegetation leading to deforestation. E, the demolition of structures. And finally, F, the infilling, the filling in of bodies of water. A building permit does not include any authorization for civil works. A separate permit is necessary. As it relates to providing more clarity, the so-called triggers, this is exactly what the ministry will be providing in the operational protocol for issuing civil works permits within short. Will the ministry consider improving the publication in National Gazette to reflect the actual location where the permitting activities will occur instead of the requester's address? And my apologies, just for the record, these are the two questions of MP De Wever, not of MP La Cruz. The National Gazette only publishes where the actual activities will be taking place. At times, errors occur, and these are rectified as soon as possible. The ministry will be putting forth amendments to the manner in which information is published in the National Gazette to make clearer what is actually being constructed, thereby enhancing transparency and clarity going forward. To the questions of MP Lyndon Lewis, is there a legal mechanism allowing individuals to petition the court if the ministry effectively refuses to make a decision on an application? Example, through excessive delay, fictieve weigering. If the ministry fails to make a decision on an application within the legally prescribed period, this may be considered a fictieve weigering or a constructive refusal. In such cases, the applicant has the right to file an appeal with the administrative court as if the application had been formally denied. This legal mechanism ensures that inaction or oversight by the ministry does not prevent access to judicial review. What is the standard time frame for an applicant to receive a decision after submitting a building permit application? And does the ministry have internal benchmarks for target timelines for issuing permits? The permits department is indeed suffering capacity issues, and due to this, there's not a standard time set for evaluation processes and final decisions at the present moment. With the staff at hand, the department is trying its utmost to complete as many permits as we can. The ministry is looking to different options to remedy this situation, including digitalization and efficient work methods. Based on Article 21 of the existing building ordinance that dates from 1935, the official time frame is 1 month. If a civil works permit is necessary, this month can be extended until civil works permits has been acquired, which has its own legal time frame based on Article 28. If the decision time frame passes without a response, does the applicant automatically gain the right to start building? No. As explained before, it means that an applicant has the right to start a court procedure based on effective awakening. In such cases, the court would most likely then order the minister to make a substantiated decision within a certain time frame. And this is actually very important, Madam Chair, because oftentimes, even myself was under the impression before this rule that if you don't get an answer from government, it means a yes. But in fact, it doesn't mean a yes. You have to actually have the right to go to court to have a decision be made within a reasonable amount of time. What recourse or procedures exist if an applicant faces excessive delay? Is temporary authorization possible? There is none, and no temporary authorization possible. What criteria determines if a permit application receives priority processing, and what is the expected processing timeline for priority applications compared to standard ones? At this moment, there is no law, policy, or process that outlines an expediting process. The ministry is, however, looking to designing such a draft policy to be delivered this year. Are any current applications designated as priority? If yes, based on what's the criteria? Yes, since recently there are permits that have been marked or to be handled with priority. For example, a permit that has recently been involved in a court case where the verdict called for a speedy handling of the permit. Other examples are permits that have national impact or interest, such as the hospital or the rehabilitation center in Point Blanche. Regarding reports of the minister's executive assistant frequently being in the permit department, is this part of their formal duties? Does it raise concerns about executive interference? Is the Secretary General aware or involved? What safeguards ensure the department's operational independence? As execution services, the so-called Diensten, like permits, falls under the minister, cabinet members are assigned as focal points to each. The assignment is critical in supporting a very understaffed ministry and in full support of the SG, whose staff bureau has critical vacancies to fully support all policy, financial, and legal requirements of the ministry. This, of course, may lead to delays and ultimately is responsibility of the minister to ensure operations run in a manner that supports the government's objectives as set out in the governing program. The SG and myself hold regular updates and task meetings to which the role and functions of the executive and operation is always respected, and the independence and authority of the SG and the ministry are always reinforced. All financial and policy directives must be signed by the SG, and I encourage the ministry to not change advices to suit new recommendations as decisions go up the ladder, but to present memos to ensure paper trail and a review of the decision-making processes should there be a need to audit decisions in the future. Therefore, MP Lewis, through you, Madam Chair, rest assured there is and will be no threat to operational independence during my mandate. Following the Westview Court ruling, how will the ministry handle ongoing projects that were approved previously but lack the now enforced civil works permit? Will the requirement be applied retroactively? Following the Westview Court ruling, the civil works permit requirement will not be retroactively applied, as stated before on several occasions, to projects that are already fully finalized. For ongoing projects, the ministry is prioritizing those with significant impact to ensure compliance. Each case is assessed based on the current stage of the works and what remains to be completed. We remain committed to a fair and transparent process and continue to support stakeholders during this transition while working towards strengthening capacity and full implementation. How will the ministry ensure consistent and fair enforcement civil works permits moving forward? Ensuring consistent and fair enforcement civil works permits is the priority of the ministry. As said before, to provide clarity and legal certainty, the ministry is finalizing a ministerial regulation based on Article 28, Sub 12, which will outline the triggers, criteria for civil works permits. In the meantime, due to ongoing capacity constraints, we are prioritizing enforcements with projects of a significant impact. Can the minister clarify why the current acting head of the permit department was appointed given reports that they may not meet all profile requirements? The current acting head of permits was appointed with consideration to several factors, including ability, knowledge, reliability, and work ethic. As minister, I stand fully behind the acting head, especially noting her continued professionalism and willingness to bring forth solutions to improve service. Were there no other qualified internal staff members available to take the acting role, even temporarily? As stated above, the current acting head was appointed because of the profile, i.e. the qualifications that were deemed to be best suited for the needs of the department, noting the very sudden passing of the then newly appointed head of permits. Moving to the questions of MP A.M.R. Otley, are civil works permits applications considered a subcomponent of the building permit process or a completely separate track? The civil works permit application is a separate process from the building permit. The building permit is assessed based on the building ordinance, while civil works permit is assessed under Article 28 of the Spatial Development and Planning Ordinance. Although the two procedures are distinct, there are certain areas where they overlap and are interconnected. What is the procedural outcome if someone is granted a building permit but then denied associated civil works permit? Again, this is new grounds to the ministry, with the new civil works permit procedure manual being introduced to the ministry within short, based, of course, as said on sub 12, Article 28A. This will be improved. Once the manual is completed, then it will be advertised, and the public and government will be informed accordingly of all aspects of the new manual. But in general, in the future, if an applicant is denied a civil works permit, the building permit will also be denied, unless if possible changes are made to the project that can result in a different outcome. What is the ministry's strategy for the main court proceedings regarding the Westview case following the injunction? The Westview case is a serious and ongoing legal matter, and as such, it would not be appropriate for the ministry to publicly discuss its legal strategy in the context of a parliamentary meeting. What I can confirm is that, in general, our position remains unchanged from what is stated in the publicly available court rulings on the injunction to which we refer. We are handling all cases with the utmost care and diligence, and will continue to act in accordance with the law and the best interests of the country. Does the minister reaffirm his willingness, as reported, to work collaboratively with Westview developers to resolve permit issues? The position has and always will be to work collaboratively with all developers. I wish to reiterate, the choice to go to court was made by the developers of Westview, not by the government. Does everyone with a past land application need to reapply, or only those whose applications are incomplete under the new criteria? I believe we've answered that, so if that's okay. Then we move to the questions of MP Irion Peterson. Has the minister seen documented evidence correspondence where a previous minister explicitly denied a building permit, solely based on draft zoning plans? No permit has been denied solely on draft zoning plans, but it has been used, that is the draft zoning plans, coupled with using the reasons in Article 22 which outline the reasons to deny a draft zoning plan, including nuisance and hindrance. So as mentioned before, this is the link between the draft zoning plans and also why you would link it to nuisances and hindrances, and then based on that, deny a permit. The MP's next question: if a precedent was set by denying a permit based on draft zoning, this wasn't applied consistently in other areas, does this indicate arbitrary decision-making? In the past, decisions were not always applied consistently. This has also been confirmed by the court and has been understandably led to concerns about fairness and transparency. As the current minister, I acknowledge these past inconsistencies, and I'm committed to improving decision-making processes and substantiate justifications for deviations, if any. Our focus on strengthening the legal and procedural framework to ensure that all future decisions are based on clear, consistent, and objective criteria. This includes aligning our practices with established laws and ensuring equal treatment of all applicants moving forward. We believe that restoring public trust requires acknowledging where things went wrong and take a meaningful step towards correcting it and prevent such issues in the future. To the questions of MP Shamida Roseberg, regarding the consideration of a grace period for civil works permit compliance, are there any clear guidelines being developed for now, and how will this work? At this time, as stated before, due to ongoing capacity issues within the ministry, we are managing the implementation of civil works permits requirements on a case-by-case basis. The decision to grant a formal grace period depends on the case and circumstance, of course, of each project, including, as stated before, its current stage and the remaining scope of work. As such, we are not in a position to establish a uniform grace period or timeline applicable to all projects. However, I want to emphasize that the ministry is committed to ensuring a fair, transparent, and consistent approach in handling all applications. Will the plan awareness campaign be general, or will there be a campaign specifically on work permits or land issuance? There will be information campaigns that will focus on individual subjects. There's an ongoing effort to identify frequently asked questions from the public, which helps to inform the ministry as to which areas need more communication. Can the minister clarify how the ministry balances a strict letter of the law, for example, objection periods, with established jurisprudence allowing exceptions? The ministry applies the law as written, including objection periods, but we also take established jurisprudence into account where relevant. In cases where strict application may lead to unjust outcomes, we assess the legal context carefully on a case-by-case basis. Our aim is to ensure decisions are both legally sound and fair. And finally, the question of MP Veronica Janssen: how many objections have been made since first publishing the building permit in November? The only noted objections have been for 2 permits, Ville-Levin and for Westview. Important to note is that many people are unaware of the National Gazette or even have the time to review it. This is why the campaign is so important to us. With that, Madam Chair, I yield the floor and look forward for any questions of clarification.
Thank you, Minister. Does any member have a point of clarification? That seems to be the case. I now give the floor to MP Irion for his point of clarification. MP Irion, you have the floor.
Thank you, Madam Chair. Good morning, honorable colleagues. Good morning to the Honorable Minister of Rummy and his support staff and the viewing public. Thank you for your answers, Minister. I'll head right into my clarifications. Through you, Madam Chair, the Minister mentioned that the ministry is working on a decree for civil works permit. And my question is, what type of decree is it? Is it going to be a LB or MB, A.M.R? So what type of decree is it? And the Minister also mentioned, through you, Madam Chair, that the decree is in the final stages. So what I would like is to know if Parliament can get a draft of what the criteria is for the current decree. So what the criteria is for the current decree. And also, am I or we as a body of parliament to assume that this only counts for permits going forward? So this decree only counts for permits going forward? In answering the question by yourself, Madam Chair, regarding the grace period, the minister mentioned that the grace periods would be on a case-by-case basis. So, and it can be granted for all. So how many of these grace periods have you granted, Minister? What was the criteria for these grace periods? So if you gave a grace period, what was that criteria for those grace periods? And what were the varying times of these grace periods? So one was 10 weeks, one was 2 months, one was a day. What were the varying times of these grace periods? And last, regarding that question, what is the legal basis for granting or not granting those grace periods? Madam Chair, through you, and I've heard you mentioned in the past that ministers really should be careful on the floor of Parliament discussing legal matters, and also that from MP Irion Peterson. Through you, Madam Chair, the minister mentioned that he already knows they will be more than likely losing 3 cases. Isn't the minister already secretly giving the plaintiffs, or not even secretly giving the plaintiffs information, or even the weakness of government? How does the minister ascertain that he will lose these cases? And is that not dangerous to you, Madam Chair? But the minister, answering another MP, mentioned in the end of his answering that he cannot go into details regarding the West View openly on the floor of Parliament to not give away the strategy of government. So I want to be clear, Madam Chair, is it then that the minister is giving away the strategy for the other 3 cases and intentionally losing those, or trying to win West View and not lose that one? So I want to be very clear. And again, I think we have to be very clear on speaking and saying things on the floor of Parliament. The minister mentioned regarding civil works permits that they would not be automatically, there would not be any automatic exemptions. In addition to that, the minister mentioned, through you, Madam Chair, that no civil works permits will be going retroactively. This will be done on a case-by-case basis. So I'd like clarity, Madam Chair. If the minister is not going back retroactively, what are the case-by-case basis permits based on? Isn't it based on the past? Isn't that every case going retroactively? Because we can't then go forward on a case-by-case basis, or am I mistaken? Or can the minister clarify that? So is it on a case-by-case basis? And again, I would like the criteria to qualify for this case-by-case basis. So we need clarity. I would like the public to have clarity on how they can qualify to be in this batch of a case-by-case basis. The minister also mentioned, to you, Madam Chair, that the department is looking at civil works permits not on a retroactive basis, but by impact in large projects. So I would like clarity from the minister on what is the definition in the ministry of a large project. So what documentation can the Parliament get on how the large projects were quantified? The minister also mentioned that civil works permits will be done based on the impact of these projects. Can the minister clarify what impact, what is the definition of the ministry's impact? What does that impact mean? Because previously, and also answering here, the minister mentioned the impact of, let's say, is it impact based on traffic or rainfall? Because a sign on the side of the road that is small can also have similar impact on the infrastructure. Through you, Madam Chair, the Minister mentioned that if you don't build within a year, a permit can be revoked immediately. I would like to know from the Minister, is there a process, and what is that process of revoking a building permit within a year? So what does that process look like within the ministry? So how do you go about that? The Minister also mentioned Love Bazooka. Have there been that Love Bazooka, 2 requests came in for Love Bazooka? What I would like to know is, can Parliament receive those requests or that the Love Bazooka that was sent out to these individuals? Can Parliament also receive a copy of those Love Bazooka? And that'll be all, Madam Chair. Thank you.
Thank you, MP Irion, for your clarifications. I now go over to giving the floor to MP York. MP York, you have your option to point the clarifications to the Minister.
Thank you, Madam Chair. Good afternoon to you, the SG, esteemed colleagues, Minister and his support staff, and the viewing public. Madam Chair, I have just a few points of clarification. The Minister mentioned in answering my question about the Ville project being issued a warning and the Westview project being issued a stop order was because the Westview project was not in, did not have a civil works permit, and that Ville did not have their civil works permit on site. Now, I would like the Minister to clarify, and I would like the Minister to really take his time before answering this clarification. Can the Minister clarify, was the warning solely based on the civil works permit not being on site at Ville, or the civil works permit not covering the full scopes of work being executed at Ville at the time? Through you, Madam Chair, I would like the Minister to really take his time before giving an answer to this question. The Minister also alluded to climate resilient measures being taken also with government projects and the climate resilience specifications, etc. He alluded to climate resilience specifications. I would like the Minister to clarify some of these specifications which are checked during approval of this climate check. The Minister also spoke on the decrees or the submittals for land issuance, and the Minister stated, Madam Chair, that once a physical copy or a digital copy of any submittal is in the hands of, in the possession of ROMI, that individual will not have to resubmit their request. But I would like for the Minister to clarify, how does an individual at home know whether ROMI has their physical or digital copy of their submittal? Are they supposed to smell this? So can the Minister clarify what VROMI will be doing to inform the people who are the ones who have submitted for land in the past, whether they are in possession of their request, whether physical or digital? Because I have no clue how, if I submitted a request years ago, how I would know if VROMI still has my request, yes or no, and whether I have to resubmit or not. Also, the Minister alluded to particular Love Bazooka being requested, being submitted. I don't know if the Minister were referring to Love Bazooka by the public or Love Bazooka by Parliament, but the Minister also referenced that if Parliament wanted any information, that they would be requested to submit a Love Bazooka. But Madam Chair, my person as well as my faction submitted a Love Bazooka, and to date we haven't. Well, the Minister asked for extension, but we haven't received any documentation. So can the Minister clarify when we can expect this, seeing that we're in a meeting that we requested the information for, and we still have no documentation that we requested? Moving forward, the Minister answered my question based on capacity for the Permits Department. Can the Minister clarify how many employees are currently working in the Permits Department? The Minister, Madam Chair, also referenced or stated something of the ilk of operation, I don't know if I understood it correctly, independence will not happen during his tenure. I would like the Minister to elaborate what he meant by this, or what does this mean? What does he mean with operational or operation independence? And lastly, Madam Chair, I'm a bit confused with the following, so I really need clarification on this. The Minister spoke very glowingly of the current acting head of the Permits Department. The Minister shared sentiments of which I'm also of the same opinion. But recently, the Minister took it to the media to express his findings or express his opinion of the Permits Department and basically accused people in the Permits Department of committing acts of bribery. Now, the Minister did not point any fingers. He painted a very broad brush. But I would like to know before stating this, if the good Minister also thought on the new acting head before sharing these sentiments in the public, to the public. Because, Madam Chair, to accuse civil servants, whether it's true or not, publicly, with no proof, with no investigation being done, I don't understand the thinking of the Minister, and it's very unbecoming of a Minister to do such without doing due diligence. So I would like for the Minister to clarify what exactly is he doing to fix this issue, because to accuse civil servants with no proof.
MP York, I do have to mention that that is a new question.
That's not a new question, Madam Chair.
Yes.
We are discussing permits and the capacity issues with the Permits Department. And if the Minister is saying that merely doing a policy handbook is going to fix it, when he publicly stated that there are acts of bribery which can be cause for hold-up of permits, I think that's all relevant to the subject matter.
So what is the clarification exactly?
The clarification is a policy handbook the only fix that he has to commit, that has to be done in the Permits Department. And basically, what he did recently, in my opinion, is managerial suicide. So I would like to understand what is the thought process in fixing these issues in the Permits Department, seeing that we're speaking about permits and all issues related to permits. I would like to know what the Minister is planning to do with the department moving forward in order to fix these capacity issues, in order to get permits out. So with saying that, I'll refrain my further comments for another moment, and that will be all for my clarifications, Madam Chair. Thank you.
Thank you, MP York. I will now go over to the next member of Parliament, being MP Doran. MP Doran, you have the floor for your clarifications.
Thank you, Madam Chair Lady. Once again, good day to one and all, and a special shout out to the people of St. Martin that are tuned in. Madam Chair, I have quite a few clarifications based on the questions that were provided, so please, I ask your indulgence. Through you to the Minister, I heard the Minister mention that they're now going to regulate the way they issue civil works permit by having a policy. Now, I understand that fully, but the question is, isn't the law pretty clear? And also, Madam Chair, I heard the Minister mention that the ministry was not aware of Article 28A. Now I have to ask myself, who is the Minister referring to when he mentions the ministry? Because if you ask me, the ministry has been working on reinstating Article 28A since 2013. And it was the ministry that prepared the advice for the law that was passed in 2021. And it was the ministry that sat with me in approving it. So when the Minister stated that the ministry was unaware of Article 28A, it raises the alarm, it raises my eyebrows, and it makes me wonder what is really happening. So I would like some clarity on that, Madam Chair, through you. I also heard the Minister mention, Madam Chair, that the zoning has no legal basis, but it's just based on best practices. Now, the Minister also mentioned something that is very important when he said that you have to have public consultation for these best practices to even be enacted. So my question on clarification through you, Madam Chair, based on what the minister mentioned, did these public consultations take place in the Kupakoi area, Simpson Bay area, and all those areas over there where we have these large-scale developments? Did the zoning consultation take place there in order to enact the best practices? Madam Chair, the reason why I say this is because at the end of the day, we all are human beings. We all have our opinion, how we see things, how we see life. We have progressives, we have conservatives, and I've been always open about expressing myself in terms of we have to build higher. We do not have the space. We are 16 square miles. We always have to build higher. So when I hear certain comments from the minister and our persons in decision-making positions, I really wonder where are we going to put all the people when we run out of space, based on all these limitations with not 24 meters, but 14 meters. Madam Chair, through you, I heard something that, sent off some serious alarms in my head, and I know you as a legal mind, Madam Chair, I saw your eyebrow went up too, maybe it could be for a different reason. I heard the minister mention that on the floor of Parliament, that government is more than likely to lose the next 3 court cases that are there. You are setting up the people of St. Martin, Mr. Minister, through you, Madam Chair, because you cannot, and I'm going to emphasize this, as a defendant, already give away and give up. So when I heard things about 2 months ago of the fact that the ministry, in certain cases, deliberately losing them by not providing information, today, this was a confirmation. This was my confirmation, Madam Chair. So I already could almost congratulate those plaintiffs because the minister already gave away the position of government. But in the case of Westview, I can't comment on it because we're going to give away our strategy. It's quite confusing. It's quite clear what's taking place, Madam Chair. It's a pick and choose situation. Madam Chair, I would like to know through you, and I heard the minister allude to it just now in the responses, but I just want some clarity on it. Based on all the building permits, maybe over 100 that the minister has issued during the last year, have you issued civil works permit for those buildings? And if not, will you be giving them a stop order, which is the same that you did to the Westview project? Because I heard the minister touch on it a bit, but it wasn't clear. Will they be getting a stop order as well as was given to the Westview? Madam Chair, I heard the minister mention that the permit for Villa Vin was not issued in 2025. I beg to differ, but I still would like some clarity on it. When was the permit issued for Villa Vin, Madam Chair, through you to the minister? Because I remember the minister saying he's against this, he's against that, but the permit was issued during his time, which it could have been held back from then. So I would like some clarity on that. Madam Chair, I also asked, which was not answered by the minister, which minister issued the permit, the civil works permit, to allow Villa Vin to develop a beach in Indigo Bay? Which minister? And in case the minister would try to insinuate that he doesn't have the permit or wouldn't know, I have a letter that was sent to the ministry dated November 8, 2024, during the current minister's tenure. I'll just briefly touch on it so that I can get some clarity. Amendment request for existing beach permit. Dear Sir, Madam, we are hereby formally requesting an amendment to our existing beach permit with aim to reflecting the rejuvenation of Indigo Bay Beach with updated amenities and improvements that will be made to the bay. This amendment is meant to accommodate those changes. However, we would like to state that the requesting the amended permit, we are not renouncing or relinquishing the rights to the existing permit that we have under 14907, which was issued in May of 2012. So again, through you, Madam Chair, to the minister, which minister issued the building permit? Because you have all the environmentalist groups saying that Doran gave them the permit to destroy the beach. And the minister sits silently, knowing better, and he has all the documents. So I want some clarity on that here today, Madam Chair. Lastly, Madam Chair, I also ask if an advice a building permit advice is received from the permit department with a positive way to move forward, and the domain, and the new works, and the, you name it, any other department issues a negative or give a sentiment, what happens? Because I can say it once, I can say it twice. Herbert Doran has never overturned a decision, or sorry, an advice from the building permit advice department to issue or not to issue. So if the minister can provide clarity, which advice supersedes the other, because we have a group of people which are allowed to not agree with each other. Everyone has their own views. And as a decision maker, you have to go with what you feel is right. Lastly, Madam Chair, I mentioned it just now, and I'm really, really, really concerned about the fact that the minister openly stated that we're about to lose 3 court cases. I could tell you for a fact my passing rate in court cases was about 80%. The numbers are there to show. And it's strange to me that all of a sudden the government can't win a case. Thank you very much, Madam Chair.
MP Doran, thank you for the last statement, which wasn't a clarification, but I will now go over to MP York. I'm seeing that he would like to have the floor for a clarification.
Thank you, Madam Chair. Through a particular interruptions during my clarification round, I actually forgot 2 questions or 2 clarifications. So I would like to pose the minister out of the air of transparency. We're speaking about building permits and civil works permits. So the following clarification. If a building permit is already approved and irrevocable, can the minister clarify how long is the process for a civil works permit? And also, can the minister clarify if this process is prioritized? And I heard a couple articles mentioned today, and made me think on the following. The building ordinance has Article 22, which governs the denial basis and denial grounds for permits, building permits. Out of transparency, where can the public find the denial grounds for civil works permits? Can the minister clarify where that can be found in the event of the public wanting to do their due diligence and find what the denial grounds for civil work permit is? And that will be it for my clarifications, Madam Chair. Thank you.
Thank you, MP York. Is there another member that would like a point of clarification? That does not seem to be the case. I will now adjourn the meeting for 3 minutes to caucus with the minister how much time he needs to answer the clarifications of the members of parliament. Meeting adjourned for 3 minutes. Good morning. I hereby reopen this meeting after deliberation with the Minister of Vromi. I will adjourn this meeting for 1 hour so that the Minister can answer the questions, the clarifications of the members of Parliament. So meeting adjourned for 1 hour. We will continue 12:40. Blessed afternoon. I hereby open this public meeting in regards to the deliberations with the Minister of Public Housing, Spatial Planning, Environment and Infrastructure regarding the delayed publication of building permits and ensuring legal compliance and procedural clarity. I will now give the floor to the Honorable Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes, to answer the points of clarifications posed by the members of Parliament in the second round. You have the floor.
Thank you, Madam Chair. Just to clarify, out of all the questions we've had, we also noted 6 new questions, and they will not be answered. The first clarification from MP Irion: what type of decree is the ministry working on for civil works permits? Is it an MB, LB, or landsboarding? Can Parliament receive a draft? It is indeed, as stated, a ministerial regulation, so an MB.
So, you, Madam Chair, just to keep order in the Parliament, can the Minister at least then notify you on which those 6 questions will be and who they're from? Because it's his opinion, but I just want to clarify that.
Thank you, MP Irion. Minister, could you clarify
Yeah, sure, no problem.
those questions? Wait a minute, Minister. I'm seeing there's other MPR.
For out of transparency for also those who's viewing the proceedings, who determines if it's a new question or not? Because if it's not determined when the question is posed, how can the minister himself determine if it was new or not? According to me, the chair determines that. I stand to be corrected. So if that's the case, Madam Chair, before anything the minister says, can you clarify, Madam Chair, who determines if something is a new question and when does that have to be determined? Thank you.
Thank you, MP York. In regards to the question posed, the members asked for clarification. I made it clear that it's a clarification round. The minister, I cannot force the minister in answering questions. So when the minister is bringing forward his point that it's a new question, then I will come to the conclusion if it's a new question or not.
Okay.
Yes, MP Doran.
Thank you, Madam Chair. Madam Chair, I've been around a little while to know that once the questions are being posed in the clarification, the chair of Parliament then determines if it's a new question or not. The minister cannot go in the room and then determine that it's a new question without giving indication. So I think that we are setting a bad example if we have to wait and see what the minister believes is a new question. If it was not established like that by the chair during the clarifications, then I believe every question is relevant, in my humble opinion. Thank you, Madam Chair.
Thank you, MP Doran. I will let the minister start with answering the clarifications, and thereafter, I will address the matter when we come to that. You can continue, Minister.
Thank you, Madam Chair. So just to continue, it is indeed a ministerial regulation. When the final necessary changes are made, it will be shared with Parliament. The question was, does this go into effect moving forward? This is MP Irion's questions. We started by saying it's MP Irion's questions.
Thank you, Minister.
Yep.
Please, before answering the question, make it clear whose questions you're answering, okay? We're now by MP Irion, right?
Yes, so when I started this deliberation, I stated these are all MP Irion's clarifications. Then what we will do, the question, what are the criteria and legal basis for granting or not granting those grace periods? Madam Chair, let me clarify. We did not introduce the idea of a grace period. This was proposed by parliamentarians in the second round, to which we determined such an initiative would have to consider several factors before it can be implemented. MP Irion's questions, clarifications. The minister shared that he expects to be losing court cases currently running. Is the minister not secretly sharing the position and strategy with the plaintiffs? Through you, Madam Chair, allow me to answer the question simultaneously for MP Irion and MP Doran, but I will, of course, reiterate several points where needed for MP Doran's clarification. As stated, we have 3 cases, all related to permits issued by MP Doran during his time as Minister of Romy.
Thank you, Minister. I'm seeing that MP Irion is standing by the lecture, so I see that he would like to make an interruption. You will make your last interruption. Oh, okay. My apologies. It was just signed by the griffier, so you have one other interruption after that.
Yes.
You have the floor.
Thank you, Madam Chair. Good afternoon to all. Minister, during your answering, you mentioned about the grace periods. But now you're saying that it's based off of Parliament's request on the grace period. So I really would like clarity on, because you skipped all my other questions also regarding the grace period, in terms of the varying times, have you issued any and so forth. You skipped all of those questions. So can you please answer the questions regarding the grace period, and have you given any?
Thank you, MP Irion. Could you answer the
Thank you.
interruption?
Thank you, Madam Chair. As stated in my presentation, the proposal for a grace period was not made by my person. It was made by members of Parliament. In my response in the second round, I outlined that any grace period would have to be given XY conditions to make favorable. I never presented the option of grace period. I was responding what would grace period would mean or take. So with that, let me just...
Minister,
Yeah?
before you continue, I do remember the MP mentioning in regards to the grace period based on what factors you come to the case-by-case basis. So I don't know if that was answered or not, but that was a question of the MP because I can remember it was my own question that he referred to.
So those are also parts of the questions that we will announce after that are, okay. I'll come back to them. There's a strategy to this. Okay. Yes, then MP Irion had another question about losing court cases currently running. Is the minister not secretly sharing the position and strategy with the plaintiffs? Through you, Madam Chair, allow me to answer this question for MP Irion and MP Doran. As stated, we have 3 cases already permits issued by MP Doran during his time as Minister of Romy in Beacon Hill. As stated, we have already lost one of these 3 cases. The buildings involved in the 2 remaining cases falls under the exact same development master plan and the exact same draft zoning plan, which regulates what can be built and how high. As such, cases of similar circumstances can expect similar outcomes. The ministry and I are very realistic. While we will try our best to understand the decisions taken in the past, the court, and in fact, the same judge from the previous verdict, have already outlined and repeated the thought process for the decisions for the first and second cases. The third case has not yet commenced, but the conditions are exactly the same. Thus, we expect it to go the exact same way. MP Arion's clarifications. What documentation can Parliament get which the ministry is using to determine the impact of civil works interventions? Or is it a case-by-case basis? And what are those criteria? As stated, the ministry is in the final stages of completing the Civil Works Manual, and if desired, it can, of course, be shared with Parliament. What is the process for revoking building permits over a year where development has not started? There is currently no process for this, nor has it been done before, but it is legally possible. MP Arion's next clarification, Lob Verzoeken. Can Parliament receive the Lob Verzoeken sent by the ministry to the client? Let me clarify. The ministry does not send Lob Verzoeken. We receive Lob Verzoeken. If the MP means can he receive what we have received, we of course are open to sharing this request. Moving now to the clarifications of MP Darrell York. Can the minister clarify if the civil works permit not being on site or that permit did not cover the full scope of work executed? This is for reference to Ville-Vin. Yes, the permit was not on site, thus a warning was issued. Upon further investigation, it was noted that the ongoing works, despite...
Thank you, Minister. MP Irion, you can make use of your interruption.
Thank you, Madam Chair. It's a bit unfortunate that we didn't, let's say, establish the questions that are not going to be answered and so forth, because now I have to use my interruption now to ask about questions not being answered, which I think is very unfair. I specifically asked a question regarding the civil works permits, and I asked about the retroactiveness about regarding the civil works permit, and the minister mentioned it can be by case basis. I asked, how is it? It's like, are these 8 questions regarding the clarification of what the minister said? So can we please either get them or let me know if you're not going to answer them?
So, Madam Chair, through you.
Thank you, MP Irion.
For the
You may
sake of
answer.
efficiency, I would like to propose, as I'm trying to do here, go through all the confirmed clarifications, and we go back to then determining the ones which are going to be open for discussion.
Seeing that there is some misunderstanding, what I'm going to decide that we're going to do is, because I do find it unfortunate that if a member thinks that their question is not going to be answered or is not answered, that it will go to the lectern. That's not the idea of the interruptions. So therefore, I will take the decision that you make it clear which questions you weren't going to answer. But I do want to make the remark, seeing that when now it's being proposed by the ministry that those questions are new questions, but when the questions were asked, I didn't get the moment from, okay, this is a new question, so it will be very difficult now to say those were new questions, because I didn't establish that those were new questions in the moments when those questions were posed. So therefore, Minister, if you would need more time, and I will take the blame for that, if it is a new question, but you would have to answer those questions because it wasn't established in the moment. So to go retroactively to decide it was a new question, I cannot do that. So as a chair, I will pay attention more to those matters if it was a new question, but you would have to answer those questions as well.
Madam Chair, then I propose we adjourn for 5 minutes, and then we continue this process.
I will adjourn for 5 minutes for you to answer those questions, and then we will have to see how far we reach, because I will have to adjourn this meeting until a later moment at 2 o'clock. So 5 minutes will be granted for now. Meeting adjourned for 5 minutes. I hereby reopen this meeting, and I will give the floor to the Minister of Romy to go straight into the clarification round, the answering of the clarifications. Minister, you have the floor.
Yep, thank you, Madam Chair. So we will go back up now to MP Irion's clarifications. Does this go into effect moving forward or also retroactively? Ministerial regulations generally apply moving forward. However, in exceptional cases, particularly where there's a significant environmental impact or public safety concerns, the regulation may be applied retroactively. Such decisions are made with great caution and only when clearly justified in public interest. How many grace periods were given? No grace periods were given. What are the criteria and legal basis for granting? Indeed, we answered that question already. So now we go on to the clarifications of MP York. The first clarification, can the minister clarify if it was a civil works permit not being on site or the permit did not cover the full scope of works being executed? In response to the MP's request, the response is both. Upon further investigation, it was noted that the ongoing works, despite having elements of drainage, was being done to improve situation and mitigate runoff that we saw was possibly impacting an internationally protected species protected by an international treaty due to the existence of outdated infrastructure. As Minister of Rummy, I must also take actions to mitigate environmental damage and protect and follow international law. And as such, they were allowed to continue to replace existing outdated infrastructure. Clarification 2. What are some of the specifications for a climate assessment? In short, the building ordinance and the existing updated code. This has, of course, been approved by the Council of Ministers and the Council of Advice. In short, some of the things that are included: provisions for higher category hurricanes, resistant buildings to category 5, earthquake and floodings. Additionally, the zoning plan is a map of the flood-prone areas, and in some areas, foundations are required to be higher to accommodate potential flooding with the increased chances of increasing risk of climate change. Long lease. How does the person at home know if Rummy has their request for long lease? How will the public be informed of such? Such a request is found by the Domain Affairs. When concerning parcel is up for issuance in long lease, this person will, of course, be contacted by the department. What's currently happening now, I think it's good to mention as well, a number of persons come to me as minister. They have a request for long lease of land. The request is nowhere in the ministry. I tell them submit a copy to again, and then it is basically be booked in. That's also for permits. That's also for general requests. You can resubmit. If you have proof of a letter, you can resubmit it. The same exact procedure applies. When can the National Alliance faction expect a reaction to their question posed to the ministry? I refer to the letter in request made for extension, which gives a date for submission as May 28th. How many employees are working in the permits department? There are 7 civil servants working in the department. What does the minister mean by operational independence? Operational independence refers to the division between the roles of the minister and the ministry, i.e., that means minister is politically responsible, but ministry is responsible for execution, operations. Allow me to give an example of this. MP, through you, Madam Chair, MP Doran alluded to when a permit was published and that as minister, I had the ability to somehow intervene in the publication. That is completely incorrect. MP Doran, his former capacity as minister, signs a permit. This is political. Once signed, I cannot stop the publication of permit as this goes back to the Ministry for Publication, which is operational.
Minister, MP Doran would like to make use of his interruption. You have the floor.
Thank you. Thank you, Madam Chair. Madam Chair, that is not what I said. I asked a question, when was the permit issued for Villa 20? And I said, according to me, it was issued in 2025. So then the minister had the rights to intervene before issuing it. Say what I say, do not say what I didn't say. And the videos are there. Thank you.
Thank you.
So I hope that can be corrected and clarified, Madam Chair.
Thank you, MP Doran. Could you answer the interruption of MP Doran?
Thank you, Madam Chair. As I stated
Minister.
exactly, As minister, I cannot intervene in an operational matter. That's what's called operational independence. If a minister has signed a permit, not because I disagree or I'm in favor with it, can I then go and change a permit? What happens after I sign a permit? It goes down to operations. Operations publishes it. If I have the power to intervene and change permits, once all considerations are made about the permit, that's intervention. That's not independence of the ministry and the process. So in fact, as I stated, what he's alluding to, Minister MP Doran at his time signed the permit. Once it's signed, it moves out of political hands. It goes to operations. So any allusion that I can stop a permit from being issued is completely incorrect.
Minister, before you continue, in regards to the question of MP Doran, that it was signed in 2025, that was a question that he asked. I didn't hear the answer.
Yeah.
Issued in 2025, my
So
apologies.
we're
Is that
still
correct
on
or not?
MP York's questions, and I use the example to indicate to him in very clear form what operation dependence means.
Okay, so that
we still
question
have
will
to
be
get to
answered.
MP. Yes,
Okay,
indeed.
thank you.
Thank you, Madam Chair. Did the minister think about the new acting head when making reference to acts of bribery? Madam Chair, it is not clear what the MP means by "if I thought about the new acting head." However, this was to send a clear message to all stakeholders on any side that these practices are illegal. Several persons in this room and across all halls have come and indicated to me instances that they're hearing. The challenge we have is that it's oftentimes very hard to bring forth evidence. It is a clear sign to tell everybody this is not possible anymore.
Thank you, Minister. I see that MP York is standing by the lectern. I will give him the opportunity to pose his interruption.
Thank you for the opportunity, Madam Chair, but this is exactly what I meant when I said, and the minister alluded to it as well, people come to him with these concerns, but it's for the minister to do his job within his ministry and not to run to the Tribune or run to the media. It's to do his job. Anyone in here, anyone outside can do that. It's for him to do his job and handle his ministry. Because at the end of the day, St. Martin, you're guilty until proven innocent. You didn't call no name. I didn't say the minister called any names, but when you allude to the fact that bribery is happening within the ministry or within the department has 7 people. When those people go on the road and people say, oh, you from permits? Yeah, you are, you just bribed. You're indirectly tarnishing people's name, and he did without any evidence. And if the minister was to investigate and catch whoever he wants to catch, you do not smoke anybody out by going to the media and announcing what you think or what you want to do. You do your job first and you talk about it afterwards. And that is minister decorum and not unbecoming as what he's doing right now. That is what I meant. Thank you, Madam Chair.
Thank you, MP York. Minister, you may continue.
Madam Chair, thank you. And as I indicated already in that same press briefing moment, we have already noticed a number of correlations between, as we stated before, delays and questions that are coming. There is a link between a number of different situations, and that was made clear. So airing out anybody has been the case. I've actually made mention of this several times during my tenure. Thank you. Moving on. Is the policy handbook the only fix to counteract illicit behavior within the permits department? No, however, it's a very impactful instrument. How long is the process for processing a civil works permit after a building permit has already been approved? This is, of course, linked to Article 28A sub 6. The minister shall decide within 60 days after the request for consent has been submitted. The decision must be postponed once for a maximum of 30 days. May. Oh, yes. Where can the public find the grounds for denying a civil works permit? All the laws of St. Martin are publicly available in the government's Lokale Wet en Regelgeving portal. I will make this link actually available publicly, so it's easier to locate, because I'm sure it's hard to do this now. In particular, the grounds for refusing civil works in civil engineering permit are set out in the Spatial Planning law. You can find them at the Landsverordening ruimtelijke ontwikkeling planning, Article 28, sub 4. The minister may withhold his or her consent of the proposed works and activities if the proposed activities would, from the perspective of public interest, give rise to serious objections due to, 1, irreparable damage to nature or the environment, 2, the current use of the land and the surrounding lands, or C, irreparable infringement on the anticipated spatial development of the land and the surrounding lands. And of course, as stated before, we can always share these more in the future. Moving down to the clarifications of MP Doran, isn't the law clear enough to define the requirement for civil works permit? No, this is why sub 12 of Article 28A was included in the new law, creating a necessary possibility to create the further criteria. While the law does not establish general requirement for obtaining a civil works permit, it often lacks the detailed specifications needed for practical implementation. That's why it's common and necessary for policies, manuals, or guidelines to be developed by the responsible ministry to clarify procedures, documentation, and evaluation criteria. MP Doran has a second clarification point. Legal basis of zoning plans. Did the zoning public consultations take place for these zoning plans, Simpson Bay and Kupakoi? All 13 draft zoning laws hold weight. All have been through public consultation. There are 5 that have gone through a further public hearing. Kupakoi is not part of this list, but still has as a policy basis as it has been presented to the public. The court confirmed this in the most recent verdict related to all draft zoning laws. Was the building permit reissued in 2025? The question was raised during the second round if the permit was reissued in 2025. As stated, the response was and remains no. However, I believe, through you, Madam Chair, the MP was asking whether the permit was issued during my term. The answer for that is yes. It was part of an ongoing operational process. And this is also what is meant by operational independence. Which minister issued the permit to develop a beach policy in Indigo Bay? It was the then Minister from me in May 2012. Which advice supersedes within the ministry? No advice supersedes the other. If there is a conflicting advice, it is up to the minister to investigate and make the right decision. Will others be getting a stop order just as Westview? All construction in violation of building regulations are liable for a stop order.
Minister, before you continue, you just referred to minister. Just for clarification, can you refer to which minister you're referring to, if you're referring to yourself or if you're referring to your predecessor, just that it's clear? And
Madam Chair, I gave a date of May 2012. It couldn't be myself or the minister before me.
okay, could you then refer to which minister you're referring to?
Should I refer
Thank
to
you.
the minister if he's not in this room to defend, or just? Okay. It was issued by the then Minister of Romy, Maurice Lake.
Thank you. You may continue.
I want to also point out, too, that in the signature that we've seen, it's still a bit hard to determine exactly who, but we do believe from the timeline that that's who the minister was. Which advice, okay. Will others be getting a stop order?
You may continue, Minister. Members?
Will others, and let me just clarify, because, I mean, I'm hearing chatter in the background. It's exactly why we refuse to list names, because the signature could be potentially 2 people. In 2012, there was a change in government. Going back to the same time, people can sign a permit when it's issued as a different day. Exactly the same exact reason why I said let's avoid names. Moving on. No, not when it's convenient, but
Members
Anyway.
and Minister, please.
Yep. Okay.
Decorum.
Why is the ministry unaware of Article 28A? During the previous administration, the concerning law was reintroduced. The ministry was apparently not aware of the implications of this law in 2021. This could be the result of not having key vacancies filled during the period. For instance, the Secretary General, together with his legal advisor and policy advisor, a permanent head of permits, and senior advisors within the policy department. And Madam Chair, that's the end of the clarifications.
Thank you, Minister.
Madam Chair, just to
yes.
clarify, because
Yes, Minister?
indeed, Madam Chair, again, this is just to clarify again, In 2012, it's either Maurice Lake or William Marlin. This is exactly why, sorry?
Members,
Guys.
members, parliamentary decorum, please. Moment, Minister, I will have to give you the floor. You have the
Sorry.
floor now. You have the floor.
Madam Chair, it seems like the Minister of Rummy at the time was Theodore Heiliger. The name, of course, is not on the document, it just has a signature. There was a discussion about whose signature it was, and this is where the complication came from, and why we chose not to mention the name in the beginning.
Thank you, Minister. I'm seeing that MP Doran would like to have the floor. Can you explain your concern? Is it a proposal? You can have the floor.
Thank you, Madam Chair. Based on where we're at in the meeting right now, I think it would be a proposal of order to highlight the fact that I asked if there are conflicting advices received, and it's, let's say, from a permit advice about a building permit, and Domain Affairs, New Works, any other department give their opinion, which one carries more weight? That was a clarification that I sought, and I did not receive a response. Okay. Thank you.
So that clarification was not answered. Can you confirm that, Minister?
Madam Chair, through you, the clarification was answered. I'll scroll back up where I stated that no decision supersedes, here we go, which advice supersedes within the ministry, no advice supersedes the other. If there is a conflicting advice, it is up to the minister to investigate and make the right decision.
Thank you, Minister. I'm seeing that MP Janssen Webster has a concern as well. It's a proposal of order. Yeah, you may have the floor.
Thank you, Madam Chair. Good afternoon. Proposal of order, Madam Chair, because I'm hearing the minister indicating that he doesn't want to call a name, and now I'm hearing 3 different names, possible ministers. I think that we should give the minister a chance to find out if he's going to call a name, which correct name it was, because I can remember in 2012, there was the Carnival Coup. That was in April. So if we're saying that it was Minister Heiliger, I'm not sure if you're looking at October, because I think the minister mentioned October. Then there was the other minister at that time was Marlin also mentioned. And then I also hear mention of Minister Maurice Lake, who came in 2013. So I think instead of calling 3 different ministers' names, take the time and if we're going to call a name, then let's call the correct name. Thank you.
Thank you, MP Janssen Webster. If there's no objection, I would like to adjourn for 2 minutes. Meeting adjourned for 2 minutes. Good afternoon. I hereby reopen this public meeting, and I will give the opportunity to the Minister of VROMI to answer the clarification of MP Janssen-Webster. Minister, you have the floor.
Yep, thank you, Madam Chair, and a special thank you as well to MP Janssen for making a suggestion to verify. It took the whole entire team of us, but we did it. And I think to clarify, the signature on the permit is that of the then Minister Theodore Heiliger. Important to realize as well, the issuance is May 29th. He ceased being minister on May 21st. Again, indicating what I said before, operational versus political instances. This was issued after his mandate of being minister. It's important that we also realize that there's a number of ways that things can happen. But the signature is indeed Mr. Heiliger. Thank you.
Thank you, Minister. I would like to thank the Honourable Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes, and his support staff for their presence here today and providing the necessary information. Ladies and gentlemen, we have come to the end of this meeting. I'm wishing everyone a safe weekend, and I thank all the members for their participation, and I hereby close this meeting. Meeting closed.